although Darnley had underwent an operation for the evacuation of hematoma. He suffered permanent brain damage in the form of a severe and very disabling left hemiplegia. Darnley brought proceedings against the hospital, NHS Trust. His case included an allegation of breach of duty by the reception staff concerning the time he would have to wait before being seen by a clinician, and also a failure to assess for priority triage. During trial, the judge found that had Darnley suffered the collapse at around 21:30 while at the Mayday Hospital, he would have been transferred to St. George's Hospital and would have undergone the surgery earlier. In those circumstances, he would have made a near full recovery. However, the trial judge also found that the receptionists are not under a duty to guard patients against harm caused by failure to wait to be seen, even if such harm could be prevented by full and accurate information about waiting times. He ruled that it would not be fair, just, and reasonable to impose liability for harm arising as a result of the failure by the receptionist staff to inform the likely waiting time. Darnley appealed to the Court of Appeal. The appeal was dismissed on the ground that neither the receptionist nor the Health Trust owed any duty to advise about waiting times. Alternatively, the damage was outside the scope of any duty owed. Alternatively, there was no causal link between any breach of duty and the injury. Moreover, even if the receptionist were in breach of duty by giving incorrect information, the scope of that duty could not extend to the consequences of a patient walking out without telling staff that he was about to leave. Darnley appealed again to the Supreme Court. In the ruling by the Supreme Court, the decisions by the trial judge and Court of Appeal were overturned. The Supreme Court's ruling noted that there is an established category of duty of care. This duty of care is owed by the hospital, and it is not appropriate to distinguish between medical and non-medical staff in this regard. The reception desk was the first point of contact between the hospital and members of the public seeking medical assistance. It is reasonable to require receptionists to take reasonable care not to provide misleading information about the availability of medical assistance. It was reasonably foreseeable that a person who believes that it may be 4 or 5 hours before he will be seen by a doctor may decide to leave. Such misleading information by a receptionist about the available medical assistance was negligent. If Darnley had been told that he would be seen within 30 minutes, he would have stayed in the waiting area and would have been seen by a clinician. He would then have been admitted or told to wait. He would have waited, and his later collapse would have occurred within a hospital setting. Darnley's decision to leave was made, in part at least, on the basis of information provided by the receptionist which was inaccurate or incomplete. Both Darnley and Tubman had told the receptionist that he was really unwell and needed urgent attention. Darnley told her that he felt as if he was about to collapse. Darnley was in a particularly vulnerable state, and in these circumstances, Darnley's departure was reasonably foreseeable. Had Darnley suffered the collapse while he was still at the Mayday Hospital, he would have been transferred to St. George's Hospital and would have undergone surgery earlier with the result near full recovery. Darnley's unannounced departure from the hospital does not break the chain of causation between the receptionist's negligence and his injury. The Supreme Court allowed the appeal and remitted the case to the Queen's Bench Division for the assessment of damages.